Okay, so let's talk about this Texas ruling on suppressors, and just dive into the weeds here for a few minutes. So if you're a North Carolina gun owner and you own or you someday want to own a suppressor, a short-barreled rifle, or a short-barreled shotgun, this video is for you. This federal judge in Texas struck down key NFA registration requirements for these firearms, and that's a major victory, but North Carolina has its own law that literally classifies suppressors, SBRs, and short-barreled shotguns as weapons of mass death and destruction. And it generally makes possessing these things a felony. The reason ordinary gun owners can legally possess them today is an exception tied directly to compliance with the National Firearms Act, or registration with the National Firearms Act. So if federal registration eventually disappears, we need to understand exactly what happens to that North Carolina exception, and that's what I'm going to walk through here in this video. But before I do, I just want to talk about what the Texas court ruling actually does. So back in 2025, in the 1BBB, Congress zeroed out the federal tax, or the federal making and transfer taxes on suppressors, short-barreled rifles, and short-barreled shotguns, and other certain other NFA firearms. But Congress left the registration system sitting there. The ATF was still requiring applications and fingerprints and photographs and federal registration and government approval, basically, even though the underlying tax had been eliminated. The plaintiffs in Texas challenged that system in federal court, and on August 5, almost 2 weeks ago, Judge James Hendricks, I call him Jimi Hendrix, appropriately named, he ruled that the challenged registration and approval provisions for these untaxed NFA firearms could no longer be justified under Congress's taxing power. And that was, I mean, that's a huge development, something gun owners have always known and agreed with, but it does not mean that every gun owner in America can simply ignore the NFA now. So the injunction protects the plaintiffs and the people in transactions, I guess, covered by the court's order only. So before anybody starts assembling an unregistered SBR or building one, I know who you are, because they saw this on Facebook, just understand that federal protection it's one question here, but North Carolina law is another. So I want to drill down on that here for a minute. North Carolina's law. And the statute that we care about here is statute number 14-288 point. I don't think I think it's point 8. And when you go through this law, just understand how backwards this law is. North Carolina begins by saying, except as otherwise provided, it's unlawful for a person to manufacture, assemble, possess, store, transport, sell, purchase, deliver, give away, or acquire any weapon of mass death and destruction. Then the statute tells us what North Carolina considers a weapon of mass death and destruction to be. And among other things, it includes a shotgun with a barrel under 18 inches, a shotgun under 26 inches overall in length, a rifle with a barrel under 16 inches, or a rifle under 26 inches overall, and any muffler or silencer for any firearm. So under the plain words of North Carolina law, your legally manufactured firearm suppressor gets placed in the same statutory category called a weapon of mass death and destruction. And violating this law, pardon me, violating this law is a Class F felony. So let that sink in there. This isn't something to be trifled with. And quite frankly, this is exactly the kind of lawmaking that we despise. Um, and let me unpack that for just a second here, because this goes way beyond one federal court case here. This is one of the fundamental problems with the way state legislatures have handled Second Amendment for decades. Government starts with this premise that you can't have this, and then the politicians gracefully create exceptions to their rules where they decide that you are allowed to exercise that right. And we reject that idea entirely. We reject that mindset. Uh, just to put it bluntly, your right to keep and bear arms did not come from the North Carolina General Assembly. It didn't come from Washington. It didn't come from the ATF. These rights are endowed on us by our Creator God. And the Constitution, both state and federal, simply their job is to recognize and protect those rights. Government does not manufacture them. And one day, these statutes need to be flipped completely around. The law should begin with the presumption that a peaceful, law-abiding citizen has the right to own and possess and carry, manufacture, and use these constitutionally protected arms. Then government should bear the burden of identifying whatever extraordinarily narrow conduct it has legitimate authority to prohibit. So current North Carolina law does the exact opposite of that. So suppressors banned, SBRs banned, short-barreled shotguns banned, and then the government gives you a loophole. That loophole is what is so important right now. So the NFA exception in section 14-288.8 creates several of them. The one ordinary gun owners care about the most says that the prohibition does not apply to persons who lawfully possess or own one of these weapons in compliance with 26 Code Section Chapter 53. That's the federal chapter. That federal chapter is the National Firearms Act. So the structure here is pretty simple. North Carolina says suppressors, SBRs, and SBSs are prohibited weapons of mass death and destruction. And then it says, but if you lawfully possess one in compliance with the NFA, this state prohibition does not apply to you. And I would say that that language is enormously important after this Texas ruling. So let's talk about people who already own a registered NFA item. Let's current owners. Maybe you bought a suppressor 5 years ago, 5 weeks ago. Maybe you have a 10.5-inch SBR. Maybe you own a federally registered short-barreled shotgun. I love all of those. You submitted your Form 1 or your Form 4. The ATF approved it. The item is federally registered. Nothing in this Texas ruling automatically deletes your existing registration. So for you, the North Carolina argument is fairly straightforward. You acquired and possessed the weapon in compliance with the NFA. That is exactly what North Carolina's statutory exception requires. So keep your paperwork, keep your approved forms, keep your trust documents. Do not assume that because a federal court struck at the registration system, that your existing registration suddenly becomes worthless. Under current North Carolina law, that documentation is going to be extremely useful evidence that you fall squarely inside that statutory exception. The harder question that people face now is the future owner. Let's change the facts around here for a minute. Suppose this Texas ruling survives, and we think it's going to. That's everything we've seen from the Department of Justice says that they're going to. This is under the current Department of Justice. Let's not mince words about that. If the left ever gets back in there, they're going to switch all this stuff around. And suppose that the ATF ultimately changes its procedures and stops requiring or accepting NFA registration for SBRs, suppressors, and short-barreled shotguns that are affected by the ruling. Now, a North Carolinian, if you go buy a suppressor federally, assume that this person is perfectly lawful, but now there's no Form 4, there's no new NFA registration, but North Carolina law still says that a suppressor or one of these other things is a weapon of mass death and destruction. North Carolina still says the exception applies when the owner possesses it in compliance with the National Firearms Act. So now we really have to answer a very important question here, and that is, does compliance with the NFA mean you must possess a federal registration? Or does it mean that you must comply with whatever the NFA legally requires at that moment? And these two are not necessarily the same thing. There's a strong argument, I would say, for the gun owner. And let me just slow down here for a second. North Carolina's language is actually, I say, pretty favorable to the gun owner on this point. The statute does not say registered in the National Firearms Registration Transfer Record. It says in compliance with the NFA. If the federal courts ultimately uphold that the NFA no longer requires you to register an SBR suppressor SBS, then there is a pretty straightforward argument. You're complying with the NFA by doing everything the law still requires. If registration is not legally required, then failing to register cannot logically, there's a big difference here logically and legally. It cannot logically constitute a failure to comply with a registration requirement that no longer exists. I would say that this is a pretty serious textual legal argument, but I would not tell anybody that the issue is settled in any way, shape, or form. And here's why there's still a problem. Let's again look at the rest of the North Carolina statute. Immediately after creating the NFA compliance exception, the General Assembly included language referring to the sheriff executing the paperwork required by ATF for a person to obtain the weapon. And that tells you something about the world that the legislature had in mind when it wrote this exception. And believe me, courts certainly look into legislative intent when they make their rulings. So the lawmakers who drafted this law were plainly operating under a federal system where acquired through ATF paperwork and NFA approval still existed, or they presumed on it existing. So if that federal system disappears, North Carolina courts may eventually have to decide what the state legislature meant by in compliance with the NFA. Now, I think that the plain language argument here favoring the gun owner is pretty strong, but you have to understand the stakes here. North Carolina made violation of this statute a Class F felony. And so this is not the kind of legal question that you casually volunteer to become the test case for. But then jump to the other side of this equation. And how the North Carolina courts have already enforced this statute. This is not some forgotten law that nobody takes seriously. Back in 2010, I think it was a case called State versus Jones. The North Carolina Court of Appeals dealt with a prosecution involving a sawed-off shotgun under this section. And the court, in their ruling, explained that the offense consists of possessing a weapon meeting the statutory definition of a weapon of mass death and destruction. That case was before the current ordinary owner NFA exception, which was added afterwards. But it kind of demonstrates that North Carolina courts absolutely treat this as a criminal weapons statute, not some meaningless technical provision. So it's not something to take lightly there. And even more recently than that, in just this year, in June 2026, State versus Phelps, the North Carolina Court of Appeals decided that police found multiple firearms, a suppressor, a grenade-like device in the defendant's home. The defendant was convicted on multiple counts, including possession of weapons of mass death and destruction. The Court of Appeals had to decide whether simultaneously possessing multiple qualifying weapons can support multiple convictions under this. And the court stated very plainly, it said that grenades and silencers are weapons of mass death and destruction under North Carolina law. The court ultimately ruled that simultaneous possession of multiple qualifying weapons supported only one conviction under the statute because the phrase any weapon of mass death and destruction was kind of ambiguous. as to the unit of prosecution. So the defendant in this case received relief on a number of convictions. But I think that the important point for this discussion is that the Court of Appeals had no hesitation whatsoever applying Section 14288.8 to the suppressor itself. So this law is alive, it's being prosecuted, and North Carolina appellate courts are interpreting it right now. So I guess the final. So what does this all really mean? Um, if you already own a properly registered suppressor, SBR, SBS, your position is pretty clean. You obtained it and possess it through the federal NFA system, and North Carolina specifically exempts people who possess that weapon in compliance with the NFA. So keep your paperwork. If you're thinking about acquiring one of these in the future without NFA registration, be very careful here. If federal registration ultimately disappears, I think there is a powerful argument that you are still in compliance with the NFA because federal law no longer requires registration. But no North Carolina appellate court, to our knowledge, has answered that question in this post-Texas ruling world. There's simply been no time. Until somebody does, there is a Class F felony statute sitting behind this question. What else? This whole mess exists because North Carolina wrote the law backwards. Suppressors never should have been classified alongside bombs and grenades in the first place. Short-barreled rifle should not become presumptively criminal because its barrel is 15 inches instead of 16, and peaceful gun owners should not have to hunt through statutory exceptions to discover whether government has graciously permitted them with the right to exercise a constitutional right. Our rights come from God. Government's job is to respect them. And one day, North Carolina needs to rewrite these laws from that premise. So yeah, the Texas ruling is good news. A federal court has they've struck directly at a major portion of the NFA registration system for these untaxed firearms. But North Carolina gun owners need to stay pretty open-eyed about this whole thing. State law still classifies suppressors, SBRs, and SBSs as weapons of mass death and destruction. The state law still prohibits them by default, and the protection that ordinary gun owners rely on is an exception requiring possession and compliance with the National Firearms Act. So for existing registered owners, it's pretty straightforward. For future owners, if the ATF eventually stops registering these firearms, we may enter totally new territory here that the North Carolina General Assembly never anticipated. So there's a strong argument that lawful federal possession without registration still satisfies North Carolina's requirement, but nobody should confuse a strong legal argument with a court decision that has already been handed down. So until this develops further, and we get more court rulings out of this thing, just understand that both federal law and North Carolina law, understand both of them before changing what you're doing. So the last thing I would add, I hope you guys have found this pretty helpful, but the last thing I would add is we don't know how these elections are going to turn out. We do know that Josh Stein would very likely veto any kind of a solution that got put on his desk. The radical communist left absolutely wants all of these things banned and confiscated. So my point here is, if you've been considering purchasing these things, you might want to consider doing it now. We've heard from all kinds of gun shops and dealers that the ATF is still accepting these things. They haven't shut down acceptance of these. So you might want to consider going through that process and getting them now, because if they ever do shut that down, then there might not be a legislative fix in the works, because we might not have the ability to get that legislation through the General Assembly. So That's the current situation. We'll keep you guys updated as we find out more about this and get more clarity, but we want you guys to know this stuff. It's not stuff to take lightly. Sadly, the General Assembly wrote this in a way that might screw us over in the end here. So that's what we've got. Thanks for watching. Please share this video with all of your pro-gun friends, and I'll be back with